Well, welcome to the show. Today is Judge DiSanto, Elizabeth DiSanto. Is that her name? Yeah, Elizabeth DiSanto. So let's get started. Let's make this bigger.
Yes, okay. We're on the record in the state of Michigan vs. Crystal Kirch, 25377. Your ears, counsel.
Good morning, Your Honor. John Goldflaw, P. 30758, on behalf of Ms. Kirch. Ms. Kirch, would you please put your name on the record?
Crystal Kirch.
Okay, and good morning.
Good morning.
It's scheduled for the pretrial in this matter.
As to the pretrial, Your Honor, we are asking for a new pretrial so I can be provided with the discovery both from the prosecutor's office as well as there appears to be video taken by the this particular matter and sent to the police department as part of this investigation of cameras that he has in the house. So for those reasons, I need the discovery. Mr. Adley has just emailed me the paper discovery, which I just got. It was originally sent to Mr. Jenke. And so therefore he's sent that to me. So we're asking for an adjournment with respect for the purpose of the discovery.
Okay, and that's right, Mr. Mack, we come in for the bond portion.
I understand.
So April 10th at 9:15 a.m. the discovery order has been signed. Thank you very much.
And I've received the trial.
Okay, very good. And so counsel bond on this matter.
Excuse me.
I didn't want to doctor. All right, April 17th at 9:15 a.m. Okay, and so currently, bond is currently $10,000, 10% bond. On this matter, she currently has another matter that she's already posted bond on, and that's on the assault and battery on her mother-in-law.
I understand that.
And so I have Mr. Matherly present because I don't know if he's aware of the background between these parties or not. So I know he indicated that there is no objection to a personal bond with tethered conditions. However, I just want to put on the record what the bond conditions are and why the court indicated in the bond that it did with the bond conditions.
And Your Honor,
So
I understand that. Thank you.
it's $10,000, 10% bond with the following bond conditions. No contact with Mr. Kirch. Not to return to the home on 6th Street unless accompanied by an officer to obtain personal belongings. Not to possess or consume any alcohol or drugs unless prescribed. Not to have access to firearms and or any weapons or have any possession of those. GPS and alcohol tethered to the Wayne County Jail. Now, Ms. Kirch is no stranger to the court. she has another matter, so she had two prior MDOP matters within the city of Wyandotte, cases, not state cases. There are two prior ones of that. Those matters ended up being nully crossed on several occasions. I believe that they were a few months apart.
I believe you're right, one was in July, one was in October.
Or September. I can't recall
In
specifically.
reviewing the file.
Yes, I reviewed this again yesterday as well because she was here yesterday for her city pretrial.
And we understand that, Your Honor, and it's Mr. Serrano, I believe, is representing here. Yes.
And so in those matters, they were nully crossed as Ms. Kirch, I believe, was working on her alcohol issues. I'm not sure.
Okay.
Yes. So then she got the city case, I believe it was end of December, beginning of January. While that was pending, she ended up arrested. Well, she posted a bond on that matter with the Wyandotte jail, was released. Had a court date that was scheduled. Between that date and the court date, she was arrested for domestic violence on Mr. Kirch. And so that is why she's currently in custody.
I understand that, Your Honor.
So,
We're not asking for any changes in the bond conditions other than a personal bond. She has the inability, she can't get a hold of anybody to post that bond. So that's why we're asking everything else except to have to come up with the 10%.
I did not know about the.
I'm sorry, your appearance for the record.
Oh, sorry, Your Honor. This is Gunnar Matherly for the People, P number 87297. I did not know about that previous DV.
There was no previous DV.
Assault battery with the mother-in-law?
Yeah, yes, sorry, and then also, the reason why I didn't object, why I said no objection in the form, I spoke to the victim advocate, Laura Dodge, about this, who's been in contact with the complainants, and that's just, I believe that the complainants are okay with that bond amendment, so that's why
Okay. The concern the court has is Ms. Kirch's ability to follow the court orders and not have contact with Mr. Kirch. And not consume alcohol.
Well, Your Honor, she's going to be an alcohol tether. It's number one. That clearly will hopefully allay this court's concerns. And if she violates the alcohol tether, then we all know what's going to happen with that. As far as the contact, she knows she can't have any contact with him. It's simple as that. She has contact with him. She will now be in further violation of this court's orders. I would only ask that she be allowed under the circumstances so I can prepare for this, and hopefully maybe we can resolve both of these matters after speaking to Mr. Serrano in some sort of resolution, but I can't speak for anybody on that. At this point in time, we'd be able to get the discovery we need and then proceed accordingly. And I need that, need her out of jail so I can get this stuff to her. And we're not asking for no bond. We're not asking for any other controls other than she doesn't have to come up with.
Yo, what's up, guys? So I'm detailing
Does your client work?
She is employed,
No,
I'm sorry, no, she does not, she's not employed, Your Honor.
Ms. Kirch, why don't you work?
She's
I'm
not,
going through disability. I was in the auto accident 4 years ago, and I actually missed a meeting with my examiner since being in here.
I'm sorry,
And what's the nature of your disability?
I've had a neck fusion, and my surgeon won't do I have a protruding disc in my lumbar, and my left leg goes numb all the way down.
Well, that doesn't seem to prevent her from getting charged with physical.
But alleged.
I'm working on it.
I understand, that's why I said charged.
Okay, yeah, sorry.
Also, DOPs, two of those that have been charged and nobody crossed. I think maybe, ma'am, you have a little bit too much free time on your hands.
Your Honor, I'll be honest with you, I just want to go back to my house. I've been in here and I've, in my way, detoxing from my husband, and I'm not trying to say anything bad about this, that. I want to be done with him. I want to be back in my life, and as you've known me from the past, this is not me, and I'm done. I want to be done, and I just want to go back to my house.
Well, you tell us that because you're not going back to the 60s.
No, my house in Southgate. I have my own house in Southgate.
Your Honor, she has a home in Southgate. It's located at 12972 Ward, in the city of Southgate. That's where she will go.
I own that house, and I will go back there, and I just want to be there and get this all done, and I don't want to speak with him anymore. I have no legal trouble previous to this. I didn't have drinking problems previous to this. I want to be done back to my normal, good life.
Do you want to respond any more, Counsel?
I would also, I've just been alerted by the OIC that there has been, the complainant's apparently been called several times from the jail, from the defendant.
I'm sorry, your name.
Detective Sable, Your Honor. I spoke to Charles Curtis, the victim in this case, and he said that the no contact has been violated. She keeps calling screenshots of the jail calls, and he subsequently blocked them so they wouldn't come through, and there are multiple attempts. One occasion, she begged him for money so she can get out, and that was on Friday.
Ms. Kurtz?
Yes, ma'am. Yes, Your Honor.
Do you have those screenshots?
Yes, ma'am, they're at ms.com. I can print them out for you.
Okay, yes, please. We're going to be. Okay.
May I approach, Your Honor?
Okay, Ms. Kurtz, I'm going to give you a warning right now. We're bringing Mr. Kurtz into the main session. There's not to be any nonverbal communication or verbal communication amongst the two of you.
Understood.
All right, so we are recalling the matter of Crystal Kurtz, 25377. All right, and Mr. Kurtz. All right.
Oh, are you there?
Yes, your name for the record, please.
Charles Lewis Kirch.
I'm sorry, what's your first name?
Charles Lewis Kirch.
Okay, very good, thank you. I'm going to have you please raise your right hand, sir. Mr. Kurtz, can you please raise your right hand?
Oh, yes.
You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
Okay, and I'm also going to give you the warning that there's not to be any verbal or nonverbal communication with Ms. Kurtz. All right, so it was brought to this court's attention during the pretrial portion, and then the court, Mr. Goldbar requested of the court to amend Ms. Kurtz's bond to allow her to be released from jail, and then it was brought to this court's attention by the prosecutor by way of the the officer in charge, Detective Sable, by way of the prosecuting attorney, that Ms. Kurtz has been trying to contact Mr. Kurtz from the Wayne County Jail.
So, Your Honor, what I handed you there was the screenshots of the call logs. I believe this is from last Thursday. Because I believe it is marked Wednesday and Thursday. There are, when you look at it, there are calls from 313224. I believe that is the number that she was calling from. And I can have the complainant here reflect more on that in terms of what he was doing. I believe it was blocked, but I believe he told me that he answered the call the first time, then blocked it after that.
Okay. And Mr. Kurtz?
Yes.
Okay. Did you receive a call from the Wayne County Jail?
Yes, I did.
What date was that?
Wednesday. I can't remember the date exactly. It was that on that Wednesday. That's on the sheet there. The exact date might have been the 19th, maybe.
Okay, so just a few days after the incident that Ms. Kirch was arrested for.
Yes. And like the gentleman said, I answered the first time. And she wanted her son's number. I did give her that. And then that was it. I blocked it from that night on.
Okay, and then how do you know that, that the, calls continued?
Well, they showed up blocked the next day.
And it was from the same number that contacted you on Wednesday?
Yeah, see, that's the thing. So when I looked Wednesday, it said prison jail, but then when I blocked it, it didn't say that. So you know what I mean? It's one of those. It doesn't say prison or jail. It just has the actual number.
Okay.
The next day, the 313 number.
Okay, so when it said prison jail as the caller ID, did it also have a number associated with it?
When it said that, yeah, I didn't, it said that on that Wednesday, correct?
Okay. And so, was there any other discussion on the phone call from Ms. Kirch?
No, just had to give her son's number.
And so it appears as though there were a multitude of other calls. All right, Mr. Mulhall?
I was under the impression that when Detective Sabo came in here, that these phone calls had occurred recently. And it appeared, I mean, the one that.
They were recent. She was arrested on March 16th. She was arraigned in this court on March 18th.
And it appears there was a call that he answered on the 19th, and she was requesting her son's phone number. He gave that to her, and that's what at least it shows.
Okay, counsel, I really am not concerned with what reason it was that she contacted him. She was ordered no contact. No contact. Not no contact except for your son's number, not no contact except to check on the pet, not any of that.
I understand that. And I'm assuming, the contact was so she could get bond money out. Obviously, because that's what they said before. He said, at least, that she was asking him for money. That's what I recall being sent before. Now, we don't have that. I understand that, Your Honor. So all it shows is that she made a phone call from the jail, and that was it.
No,
Fine, so that.
then there's subsequent phone calls, 3.
Well, we don't know
6,
that.
9 minimum calls.
She made no contact with them, and they were blocked. But regardless, Your Honor, with respect to that, there was a showing she made one phone call that was at least confirmed that she's the one who made that phone call. And my assumption, since I wasn't present even at the arraignment, was that she was trying to get some money or get contact with somebody so she could bond out.
Well, that somebody should not have been Mr. Kirch.
If that was the only way, you're right, Your Honor, she shouldn't have called him, but there was no one else to call because that's the only phone number she had. It was a mistake on her part. Like I said.
Mr. Manderly?
Your Honor, given the recent cover today, I think it would probably be best to maintain the bond conditions, just what they are, not lowering or anything like that.
Well, there was no lowering, Your Honor. We were just asking for.
We were asking for a personal
personal
right,
bond.
So that'd be lowering the bond. And the court is not inclined to do that, given that your client is currently in the Wayne County Jail, and while she's been in Wayne County Jail, she's in contact with the individual she was ordered no contact with. And then there's multitude of additional attempts to contact Mr. Kirch, but for him blocking the number, there would have been contact. But in any event, she was still contacting Mr. Kirch.
If you've forgotten to get that special someone in your life
in direct violation of this order, and that is while she's in custody. So the court doesn't have much faith in the fact that when she's not in custody, that she's going to follow this court's orders. So the court's going to deny the request to amend the bond to be personal bond.
Thank you, Ron.
Bond and conditions are continued.
Ms. Kirch, get a hold of your son if you have that number. And so you can bind it out.
I do not have the correct number. I was not given the correct number.
Your Honor?
No, hold on. Yes, Mr. Kirch.
Excuse me?
Yes, Mr. Kirch.
You know, I would like to say something. I'm not in fear of my life like they asked me. I just know she has a problem with drinking and she needs to stop drinking, and I don't want her around my residence because she destroys my personal property. Other than that, she needs to get her life on track. We are going through a divorce. She really needs help with the drinking. That's all this stems from that. With all the prescriptions she's on, I'm no doctor, but I do know she does not need to be drinking. She's an animal when she's drinking. I'm not in fear of my life. Am I afraid that if she's drinking, she might get physical with me? Yes, but I just don't want her around my residence. That's all. I think she needs to get out and get her life on track. But she cannot be around my residence. This is too much. She destroys my house. She leaves my windows open, leaves my garage door open all weekend for people to steal my stuff that I've worked so hard for.
Mr. Kirch, thank you very much. I'm hearing everything you're saying. And those are all reasons why this court wants to make sure that the bond conditions are going to be complied with. And Ms. Kirch has had a number of opportunities. She's had matters dismissed a number of times, and the matter actually continues to escalate. Ms. Kirch, would you like to be tethered to treatment?
Yes. Would you like to be tethered to alcohol treatment?
I don't quite, just meaning like an alcohol GPS tether?
No, ma'am. No, ma'am. Are you interested in inpatient treatment for your alcohol addiction?
I would like to talk to my attorney on the side about that, if that's possible.
Okay.
My advice to you is the answer is yes.
Okay. I mean, how long is, my issue is right now, I go to therapy weekly. I've been in therapy for 8 years. I'm missing my therapy appointments. Like I explained earlier, I already missed my examiner appointment with my disability examiner, so I am, like Mr. Kirch had said, I am missing things that need to get my life back on track being in here, on top of not having my my duloxetine from my Cymbalta for my mental health. So there are things like that, but I don't know what alcohol treatment is going, if I'm on an alcohol tether, I can't drink,
Ma'am?
Yes, Your Honor.
It appears as though, even though you've been in treatment, that there's something that's not working because behavior's been progressing. So the alcohol treatment, ma'am, if you're to be tethered to treatment, that would assist you in working through your addiction with the alcohol. You would have treatment appointments. You would have therapy appointments. I'm not saying that your current therapist isn't somebody that you can maintain upon your discharge, but that you would be tethered to treatment during your bond phase.
Okay, if I can please just say, while my husband and I were separated and I was back at my house, even without the tether, I was not drinking at all. Even without the tether, I was not drinking at all, and I had no problems with not drinking at all.
Do you want to be tethered to treatment for alcohol or no?
What do I have? What is my other option? Like,
Post a bond.
Post bond or stay where you're at?
okay, so how long is alcohol treatment?
Well, you'll be there at least until your next court date of April 17th.
Okay, then yes, please.
All right. So the court will amend the bond to $10,000 personal bond so she can be tethered to treatment.
Thank you.
Thank you, Your Honor.
So you're not going anywhere but treatment.
I understand that, Your Honor. Thank you, Your Honor. And can I ask one more question, please?
What's that, ma'am?
The number, because I am admitting I did contact my husband for my son's number. I'm not, that is true. I don't have the correct number, and I have no other, the only reason I contacted because I don't know any other numbers, and I would like to be able to speak to my son.
Ma'am,
Yes.
I'm not
Yes,
going
ma'am.
to facilitate an exchange of a phone number right now. Once you get to treatment, perhaps somebody from the treatment providing team can contact Mr. Kirch to get that information.
Okay.
Not you, okay?
Okay. Thank you, Your Honor.
See you back April 17th. Thank you.
Thank you.
Thank you.
Mr. Kirch,
Yes,
all right, have a good day.
thank you.
And I really want to go to trial because making me blow 13 breathalyzers and charging me with something that with only one, you know, I was falsely arrested anyways.
The City of Wyandotte, it's Robert Allen, 241508. Good morning.
Good morning, Your Honor. Mark Watt on behalf of the defendant, Mr. Robert Allen. Your Honor, there is an oral motion that I'd like to make, actually two.
Okay, just a moment. Mr. Allen, your name for the record, please.
Robert James Allen.
Okay, so today's the date scheduled for sentencing in this matter. This was adjourned from April 28th. And, counsel?
Yes, well, just so the court's aware, Your Honor, Mr. Allen did renew his medical marijuana card. He brought it with him. But the motion is, well, the first motion would be, Mr. Allen would respectfully request the opportunity to withdraw his plea based on what I believe to be the perception of my ineffectiveness in representing him during the plea negotiations and his acceptance of the plea. He's, without breaking attorney-client privilege, he doesn't believe that I properly advised him. So the first motion would be to allow Mr. Allen the opportunity to withdraw his plea in the interest of justice if he so chooses. All the witnesses are police witnesses and all the evidence is captured on body cam and video. So I don't think the prosecution will be prejudiced. The second motion.
Well, hold on. Before we move to the second motion, I'm not going to even consider an oral motion to withdraw a plea. That all has to be done in writing, so that the prosecutor has an opportunity to respond.
I understand.
Because this plea was taken on March 12th, so now we're over 2 months ago, and I need to be able to review the motion to determine whether or not that is something this court would grant. And counsel, your next motion.
The second motion, Your Honor, would be, since there has been a breakdown in the attorney-client relationship, I would respectfully move to withdraw from the case so Mr. Allen could either secure new counsel or request court-appointed counsel so that they could properly file the motion. I don't know if they want to file against their hearing or anything, or if the prosecution would be in opposition to it.
Okay, and so counsel, when did this all come about?
Well,
Did it just come about this morning?
we have been discussing it for a few weeks, and this morning it just came to a head that I can't effectively represent Mr. Allen anymore in line with what he believes to be his best interests as opposed to my conflict with what's happening here.
Okay.
I was retained in a candor with the tribunal. I was retained by a third party who did give me $2,000 to represent Mr. Allen. I proposed that I refund half of that to Mr. Allen at a minimum so that he could.
You refund that to Mr. Allen instead of back to the third party?
To the third party, but basically if they wanted to help him again, I can't in good conscience or refund all of the retainer. I've been down here several times and put quite a bit into this matter so far. So I will be refunding $1,000 to that individual.
Okay, so my question is, counsel, if this was something that was a possibility, why there wasn't a written motion filed before this morning?
I literally believed everything was fine when I was informed of the medical marijuana card, and that it was just the cold feet issues that some of my clients have, and until they give me like clear, unequivocal, I couldn't interpret. I didn't know, you didn't tell me I want to withdraw my plea in any other light than, okay, you're telling me you believe I was ineffective at this point, and what my thoughts aren't in line with what his beliefs were during these last few weeks. So I do apologize. You're correct that if I knew, I should have filed a written motion, but we discussed it. I said I could withdraw as your attorney, you could find someone else and things like that without getting into the nitty-gritty of it, but it was my belief that the representation was still intact and we were on the same page. And I apologize for interrupting the proceedings earlier. That's when it basically clicked that this is something that I need to bring forth and make these requests.
Okay. Mr. Allen, you have been to court a number of times with Mr. Iwata, correct?
Yes.
And you've had opportunity to speak to Mr. Iwata on a number of occasions, correct?
Yes.
And you also have had the opportunity to review discovery with Mr. Iwata, is that correct?
Yes.
Okay, and Mr. Iwata has been your attorney since January, and there's been a number of court dates that have been scheduled. In fact, you all were here April 28th, and we did not hold the sentencing because your client indicated that the CCH was inaccurate based upon what you had represented and requested time to adjourn that to revisit that issue.
And it has been corrected by probation, Your Honor.
Correct. Would that be correct, Mr. Allen?
Yes.
All that is correct, right?
Yes.
Okay, and so now here we are at the date of sentencing, and you want to have a different attorney, and you want to withdraw your plea.
I don't necessarily want a different attorney, but I want to withdraw my plea because I don't feel, first of all, probation ain't even part of the punishment for what I pled guilty to. I took the plea agreement thinking you were going to sentence me accordingly to what the probation, and that's not even part of the punishment.
Pause just one moment. What is it that you believe is the punishment for a first offense misdemeanor?
MCL 750, whatever else it says on there, the punishment is only 93 days in jail, $300 maximum fine, community service, a 30 to 90 day license suspension, and up to 4 points on your license. I already got the 4 points. I already got the 90-day maximum suspension. I know you're going to charge me the $300 maximum fine. I feel like that's more than enough punishment for a first-time misdemeanor offense. I've never been arrested for anything alcohol-related in my life. I'm 48 years old. Never been in trouble in Wyandotte. You're trying to, the clean slate law is supposed to erase my whole record. You're not even supposed to be bringing up my past record on me. Not the probation department lady already lied on me, put stuff on my record that I wasn't even convicted of, putting 12 to 18 months probation. That's not justifiable for punishment for what I did. What I did is, it doesn't even include probation for the punishment.
Your Honor, Mr. Allen's statements to me was I did not disclose to him that probation was a possible sentence.
Probation ain't part of the
Stop
punishment,
interrupting the
though.
record, Mr. Allen.
So I want to pull my plea because
Stop interrupting the record. Your attorney is speaking right now. Just one moment.
And I do not recall telling him that yes, probation could be part of the court's sentence, or that no, probation wouldn't be part of the sentence. I just assumed that that Mr. Allen knew that probation could be part of the court's sentence.
Okay.
So
it's not part of the law.
I understand that, sir. Nevertheless, Your Honor, there has been a breakdown in this relationship, and I can no longer in good faith continue this representation, Mr. Allen, not only for the defendant, protecting the defendant's interests, but also now my own interests, because I'm in a position where I could be looking at a possible grievance if I continue representation at this juncture.
Okay. Mr. Allen.
Yes, ma'am.
So you're telling this court that the matters that you have on your criminal record, that those have all been dismissed?
No, I said I qualified for the clean slate law, and it was my understanding that my past record would not be brought up against me. But here I am, and everything on my record is.
We're gonna take one thing at a time. You understood that you were eligible for the clean slate law. So what does that mean to you?
The lady the representative told me that we went over my record, the CCW on my record, the false report of a misdemeanor, the attempt to receive and conceal, all that was supposed to be erased off my record. It was never supposed to be brought up against me ever again. I was told if I got in trouble again, that none of this would be brought up against me. It would be like I'm getting in trouble again for the first time. So, therefore, the probation.
Which convictions are those, sir?
Huh?
Which convictions are those that you're speaking of?
The CCW conviction from 1997, the false report of a misdemeanor from 2004, and attempted receiving and concealing from like 2012 or whatever, or 2010 or whatever that year was. All of them are more than 10 years ago. You ain't even supposed to be bringing this up against me.
First of all, 2010 isn't on here.
Well, whatever the year was for the attempted receiving and concealing.
Okay, that's not on here, sir.
Okay, so well, everything else, so there should be nothing on my record.
That's not true. That's not true.
What? There shouldn't be nothing on my record
Sir,
then.
you have a number of criminal convictions, more than just what you spoke of. In the clean slate law, there are certain convictions that are automatically wiped off per the Michigan State Police, from the Michigan State Police per that law.
Yeah.
Sir, the court is looking at some of these, and if you're
trying to prosecute me for my past, say it.
Sir, the court doesn't prosecute. Let's clarify that. The court doesn't prosecute. If you are eligible for any of these convictions, sir, to be removed from your record, then you have to follow the steps that have to occur, right? There's motions to set aside, there's applications to set aside convictions and whatnot. So those are the steps that have to be followed. Some of these are not automatically wiped off.
Can I say something though? I was told since I was a Detroit resident that it does automatically get wiped off. I didn't have to do nothing. The system would automatically update itself.
Okay,
as a Wayne County resident, that's what I was told.
Detroit resident or Wayne County?
Detroit resident, I'm sorry. As a Detroit resident, if the system was supposed to update itself and erase itself, I didn't have to do nothing.
Okay, well, I have to tell you that's the first I've heard of that. I haven't heard that anything is resident specific.
You probably haven't had to go down there and talk to somebody that had your record expunged either.
Sir, I'm still given the laws to review when they're passed and then they're enacted. So I don't recall seeing anything about being resident specific. And then why would it be only a benefit of Detroit residents if it's a state statute? So whatever that is, I don't know. I don't know if there's a misunderstanding somewhere. I don't know.
Ignorance ain't an excuse for not knowing the law.
You're correct, sir.
That's what you tell me. That's what you would tell me.
You don't presume what I would tell somebody or you. Do not presume that, sir. Now, as well as whether or not probation is something that is a possible consequence, okay? Probation is something that the court would order in lieu. Sir?
Excuse me.
Those gestures are not necessary. The gesture of money, money, money. Not necessary. No. Probation is something that courts impose in lieu of jail, sir. Now, under MCL 769.5, have you reviewed that one, sir?
No, I haven't.
Okay. Well, then I would suggest you review it, because that gives the court judicial discretion if it determines that there is a rebuttal, that the presumption has been rebutted to sentence somebody to probation. Now, if you don't agree to probation, that's your right. And the court also has the right then to impose jail, if that's what the court determines it's going to do. The court also has the right to impose fines and costs only. The court has a lot of judicial discretion, sir, in imposing sentencing. So.
With all due respect, I apologize, Your Honor. I just feel like the recommendation by the probation department is way too harsh for a first-time misdemeanor offense. That's all I'm saying.
Okay, and sir, you have the right to have, Sir, you have the right to have that opinion.
I
You absolutely have the right to that
I just wanted
opinion.
to say that, Your Honor. I apologize. I'm not trying to be disrespectful. I just don't agree with the punishment for the crime. That's all. If you put me on probation, I feel like you're setting me up for failure. That's
And
all.
why is that?
Because first of all, I'm on SSI. My $900 a month is gone before I get it. I don't have no thousands of dollars to give you. My license has been suspended
Let's
for
clarify, you're
90
not
days.
giving it to me, sir. Let's clarify, you're not giving me money.
But I'm saying I don't have any money to give anybody, is what I'm saying. The 90 days, my license has been suspended for the maximum 90 days. I haven't seen my granddaughter, my goddaughter, or my kids in over 30 days. I'm stressed out, I'm sad, I'm depressed, I'm sorry.
Okay, sir, I can understand and appreciate all
I
of
feel
that.
like,
But let me just
but
clarify.
this is my first time.
Let me clarify,
I
sir.
feel like this is more punishment.
This court does not suspend your license. The Secretary of State did that.
I understand it, but it's still a punishment, a part of the law of the punishment. And I've gone through that punishment. And now I'm hurting because I can't see my own kids now.
And why can't you see them?
Because my license are suspended.
They can't come to see you?
My son don't have a car. You know what I'm saying? My daughter, she goes to nursing school. She's a full-time mother
Okay, so where does your daughter live?
in Woodhaven.
Okay, and you reside?
I live in Detroit, and it costs a lot of money to take an Uber back and forth that I don't have the money for.
Okay, what a bicycle? What about a bicycle? What about somebody
I'm
else?
disabled. I'm gonna ride a bike from Detroit to Woodhaven.
Sir,
You're asking me, man, this is ridiculous, man.
I'm just asking options.
Can I just get a fine and go about my way, man?
And sir,
You're trying to punish me too much for a first-time misdemeanor offense. I've never been arrested for anything alcohol-related. This is a 90-day misdemeanor. You're talking 12 to 18 months probation. That doesn't fit the punishment of the crime, man. That's too harsh. Even with the criminal record that I have, 12 to 18 months probation is too harsh. I haven't committed any crime. I haven't been convicted of anything in more than 15 years. This is the first time misdemeanor offense. It should be a fine and my license suspended and have a nice day, sir. If I come back here again 2 or 3 times to keep drinking and driving, yeah, then I can see getting 90 days and all these probation and all this. But this is the first time misdemeanor offense. I feel like you're being way too harsh on me.
sir, I haven't assessed anything at this point.
But I already know what you're gonna do. I sat in your courtroom and watched you sentence 10 people. And ain't nobody walked out of here with under $2,000 in fines, all kind of probation and everything, bro, for misdemeanors.
Okay.
This guy just got all this for all these probations and 2 years probation. And he did assault and all this, and you're trying to give me 12 to 18 months probation for a simple misdemeanor?
Sir, first of all,
How could they even recommend that, bro?
your conviction is eligible for early discharge. So if you want to start comparing the
It's
cases,
not eligible.
stop interrupting me. Stop interrupting me. If you want to compare cases, then you need to have all the facts. You don't know all the facts on every case. This court takes every case, every individual that comes before it, and reviews the report, the recommendation, criminal history, what other special circumstances there are before this court fashions a sentence. Now, it may seem from your perspective that they're very similar because some circumstances, right, some offenses benefit from similar rehabilitative conditions.
It's a simple misdemeanor charge, man. It
That's
shouldn't
your
be
opinion, sir. That's fine.
blown out of proportion. That's all I'm saying.
Well, sir,
If I come
you also
back 2 or
have,
3
you
times
also
for
have the
drinking-
option of after you consume the beers to have somebody else drive you home, then you wouldn't be here.
You're right. And I really want to go to trial because making me blow 13 breathalyzers and charging me with something that with only one, you know what I'm saying? I was falsely arrested anyways. I was falsely arrested. The officer told me, I don't like how you're talking to me. If you don't quiet down, I'll take you to jail for disorderly conduct. That's not disorderly conduct.
You're not, I'm gonna.
I want to withdraw my plea and go to trial.
Sir, stop talking, please. Stop talking. The court's going to grant Mr. Awada's motion to withdraw. Based on the breakdown of the attorney-client relationship as far as the direction of resolution, it appears that there's a clear difference of opinion. Mr. Allen, are you intending to retain
Oh, yes,
other counsel?
I'm gonna hire another lawyer. Somebody that's gonna fight for me. I took this plea to be cool, you know? I wanted to go to trial the whole time. I took
Sir,
this plea
you don't need to
under
keep
my
talking.
lawyers.
Stop
Okay,
talking.
I'm just
Stop
saying.
talking. As of now, this is still scheduled for sentencing until this court receives a written motion regarding a plea withdrawn. So, sir, when you have when whoever it is that you're going to be speaking to and retaining, when your attorney sees that on the docket it's scheduled for sentencing, that's because that is what's currently on the docket for procedurally. There has not been a written motion to withdraw the plea. This court's not going to entertain an oral motion because the prosecutor has an opportunity, has to have an opportunity to review the motion and file a response. So we'll adjourn the sentencing.
So I'm not gonna be able to pull my plea and go to trial? I'm just gonna be able to hire another lawyer for sentencing? Or am I gonna be able to?
Sir, do you listen to what's being said, or are you just wanting to say what you gotta say?
I'm listening to you,
What
I'm
else?
asking for clarification.
What I said, sir, was that it's going to be scheduled for sentencing, because that's what's currently procedurally scheduled.
I
There is
understand
not-
that part.
There has not been a written motion received by this court yet.
Okay.
So once there's a written motion, it will be set for a motion date.
Oh,
But as of now, this court's not just going to set it for a motion date, because I have no idea who you're going to retain and what that attorney's strategy is going to be.
Thank you, Your Honor. I just wanted clarification. I'm sorry. I apologize.
You will adjourn sentencing to be June 18th. At 9:30 a.m. That's a Wednesday. And I did that so that in the event your attorney files a motion to withdraw the plea, it will be set on a date that's a wind-down day. So that will be a motion hearing date. Now, sir, I'm sure Mr. Arvada is going to tell you that there's procedure for motions. Notice has to be given so that you need to retain an attorney sooner than later. If you're in a test right now, sir, what's in your system?
Just marijuana, Your Honor, like always.
And when did you obtain this medical marijuana card, sir?
I went and got it like probably 10 days ago.
Okay, and so did your treating physician, give you any documentation to?
My primary caregiver, she retired, Your Honor, so.
No, sir. I'm
Yes, she
asking your
did.
primary caregiver.
I mean, not primary caregiver, I mean, my primary care physician, my primary doctor that I used to go see,
Okay,
Wendy McKay, she retired, so I don't have no way of like going in and talking to her anymore or nothing, so.
okay, when
I
did she
would have to
retire?
get a new, a couple of years ago.
Okay, so who have you seen in the meantime?
I haven't seen nobody because they sent me, the new doctor that they assigned me was way out on 14 Mile and something, and I didn't need to go to the doctor since then, so I just never been out there.
Well, sir, the court does not accept a marijuana card from a marijuana clinic. The court indicated that the court already indicated what the requirements
I
were.
told you a doctor, you can't go into your doctor and say, hey, doctor, can you write me a letter saying you feel like I need to be on weed? Doctors don't do that. You
That's
can't do
incorrect.
that.
That's incorrect, sir.
I don't know what doctor you talk to, but they don't do that.
Sir, I'm not.
I asked my doctor before
I
for
told you
that,
what
and that's why I got the card.
Sir.
They don't do that.
Well, you know what? Then we're gonna have to hold a hearing on your card and whether or not that doctor's going to come in to see how long.
Let's
that
just handle
doctor's
this
been treating
first,
you.
okay?
I'm sorry?
Let's get let me hire the new lawyer, let's go get this, because we can argue about that later, man.
Well, in the meantime, sir, you're probably going to be coming back for a bond violation.
Yeah, okay. I didn't violate my bond. What are you
Sir?
talking about?
Sir, you're using marijuana. That's in violation of your bond conditions right now.
You told
And
me if I
once,
take medical
once you've
marijuana.
been under the jurisdiction of this court, the requirements for medical marijuana are clear.
You know I'm using it for medical reasons. You see my paperwork, Your Honor. Why are you doing this? This is what
Sir,
I'm
if
talking
you have
about.
medical reasons, then you would have a doctor that you are treating with that would determine whether or not the medication is appropriate. I'm not going to argue with this any further. If you're testing and you're testing positive for marijuana, then we'll have a bond violation. All right, bonding conditions are continued. Thank you. Have a good day.
Thank you, Your Honor.
And we are on the record of the city.
That's the sound of
Whether they're misdemeanors or not, sir, you still didn't show up to court. So
I
whether you
understand.
think it's a misdemeanor.
I didn't take his self-note, Your Honor. I'm not guilty of none of this.
Well, let's go with Mr. Larson-East here. We are on the record of the matter of the state of Michigan. First, Michael Larson-East II, 25597. And counsel, your appearance, please.
Your Honor, John Goldthorpe, P 30758, on behalf of Mr. Larson-East. Mr. Larson-East, would you please put your name on the record?
Michael Larson-East.
Okay, and detective, your name for the record, please.
I'm Detective Sergeant Bruce Herrick, Herrick, with the Riverview Police Department.
Okay, please raise your right hand and solemnly swear to affirm the testimony about to give us may be the truth, the whole truth, and nothing but the truth.
I do.
All right, you may proceed on the warrant, detective.
On April 28th, 2025, at approximately 5:56 a.m., RIPD units were dispatched to the area of Grange and James Road in the city of Riverview for a suspicious person wearing a mask in the area. Officer Alderman made contact with the caller. The caller said that he was taking his morning walk on southbound Grange Road and saw a person kneeling in the grass. He said the individual had a bunch of property on the ground and he appeared to be tampering with the rear gate of the property at 1 Brentwood Drive. The caller yelled at the individual, who then fled on foot northbound in the grass on the west side of Grange Road. The caller lost sight of him in the area of Grange Road and James Boulevard, but described the subject as wearing a blue hoodie, blue jeans, and a white mask. Officers checked the area and located a mountain bike in the bushes near 17861 Brentwood Road. They also found a Toro lawnmower a few hundred feet north from there, pushed into the wood line. Officers would later determine that that lawnmower belonged to the resident at 171 Brentwood Drive, the fence, the area the caller had seen the subject tampering with earlier. At 6:40 a.m., a second caller called and said that he found a purse hanging from his fence. He checked it and saw that it belonged to his neighbor, who would be victim number 1 from 1 Meadows Drive in Riverview. Officers contacted victim number 1, who said she was missing several bank cards out of her purse. At 7:53 a.m., victim number 1 called Riverview Police and said that she was alerted. Her cards were being used at Kroger in Southgate. While officers were on the way to Kroger, victim number 1 called back and said that she, along with her husband, had drove to Kroger and located the suspect, who they described as a white male wearing blue jeans, a black and red jacket, exiting Kroger with 2 full shopping carts of merchandise. Victim number 1's husband then confronted the subject in the parking lot, who abandoned his carts and fled north through the parking lot on foot. As victim number 1 was following the suspect, he was retrieving objects from his pockets and throwing them. Victim number 1 lost sight of the suspect and then went back to retrieve the objects he was throwing, finding them to be the bank cards that she was missing, along with several other bank cards belonging to a second victim. Officers were in the area looking for the suspect when Chief Allen of Riverview Police saw a white male wearing blue jeans and a blue sweater quickly walking east from the location on Quarry Road, north of Pennsylvania Road, in the city of Wyandotte. Chief Allen saw the male cross over 23rd Street and then proceed to go into a residential property, where he then jumped the backyard fence into Wyandotte Memorial Park. Officers from surrounding agencies were able to catch up with the suspect, who was then apprehended and identified as Michael Larsenis, the defendant in this case. Larsenis matched the original caller's description and partially matched the description victim number 1 gave, the only difference being the jacket color. Larsenis was placed under arrest for suspicion of larceny and transported to RIPD. Among his possessions in Larsenis' pockets was a small screwdriver, flashlight, $10.47 in loose change. He also had $201 cash, a new pack of menthol cigarettes, and 3 lottery tickets. As part of this investigation, I was able to determine the owner of the other bank cards victim number 1 had found in the parking lot to be victim number 2 resides at 1 Hilltop Lane in the city of Riverview, which is a short distance away from victim number 1 in the same subdivision. Victim number 2 was missing his entire wallet from his vehicle that had been parked unlocked in his driveway. His wallet contained several bank cards, including the ones that were found in the Kroger parking lot. Victim number 2 checked his card activity and found that a $100 charge happened at Marathon gas station on Pennsylvania Road in Southgate, and an attempted $400 charge at Kroger in Southgate that was declined. I was able to get video of both these locations, Marathon and Kroger. Marathon video shows a white male matching Larsenis' description, wearing blue jeans, black and red jacket, and a blue Detroit Lions hoodie underneath. His hood is pulled up and he's wearing a white N95 style face mask. He also has on distinct tan hiking shoes. The male in the video goes to the lottery ticket machine and purchases several lottery tickets, which he then scratches and presents to the teller. $150 in cash winnings is given to the male. He uses $20 to purchase an additional single lottery ticket from behind the counter. The male then scratches the ticket, presents it to the teller, who then gives him additional $100 in winnings, for a total of $230 in cash after the $20 purchase. The male then purchased a pack of menthol cigarettes and a Red Bull and left the store. This total is consistent with the amount of money Larsenis was found with, which was $201 cash. Kroger video shows the same white male with the same clothing at a self-checkout at 7:15 a.m. The male goes into several different pockets, as well as what appears to be a black purse and fanny pack, retrieving many different bank cards and attempts to use them. Several are clearly identifiable as belonging to both victims, which he eventually dropped in the parking lot while fleeing. The male leaves Kroger with 2 shopping carts of merchandise on video and confirms victim 1 confronts him in the parking lot, where he then flees, corroborating victim 1's statement earlier. Larsenis' Merrill brand hiking shoes, blue Detroit Lions jacket, blue jeans, all match surveillance video footage from Marathon and Kroger. And his possession at the time of his arrest, including the small screwdriver, flashlight, large amount of loose change, $201 cash, new pack of menthol cigarettes, 3 lottery tickets, support Larsenis being responsible for these crimes. Larsenis has an extensive criminal history dating back to 1989, including felony convictions for receiving and concealing stolen property, possession of a financial transaction device, identity theft, illegal sale use of transaction device, and his most recent felony conviction in 2024 for felony controlled substance possession. He also has many other misdemeanor convictions that include larceny, B&E vehicle, and retail fraud. Larsenis also has several warrants for his arrest with different downriver communities. And as a final note, I will just say that Detective Haskin from Riverview PD is working on a case involving 3 victims that occurred on 3/16/2025 in the same subdivision area of Riverview, case number 25-2812. During the investigation for this case, Larsenis was identified through video as being responsible for Lowe's larcenies as well. Detective Haskin will be sending his investigation for that case to the Wayne County Prosecutor's Office for review shortly.
This is Yariv Citron,
co-founder and CMO at Mailus.
Mailus is one of the biggest D2C brands in the US at the moment.
Yariv has a problem.
He constantly can't sleep well, knowing that he's way too reliant on one ad channel and want to find channel diversification solution.
I always tried to seek for channels that will reduce that dependency.
Then one night, while scrolling through X, he saw a post that changed everything. With a few minutes, he knows this is the new DTC channel era. Axon gives you 30+ seconds of undivided attention to maximize performance and engagement.
And to me, it was mind-blowing. We started at $4,000, and I believe that after a few days, it went to $150,000, $180,000 a day. The ROAS was much better during these days than in compared to any other channel that we have been seeing. Uploading quickly became bigger than
Record.
Michael Larsenis.
Okay, well, counsel, as to the arraignment.
As to the arraignment, Your Honor, I've had an opportunity to discuss this matter with Mr. Larson. He would stand mute to charge, waive formal reading of the information and ask that a plea of not guilty be entered. I did go over those charges with him.
All right, the court will waive the formal reading. Sir, you do have the right to have an attorney. If you cannot afford one, you can have one appointed to represent you. And you've had an opportunity to speak to Mr. Goldpaw today, correct?
Yes, sir, ma'am.
All right, and as soon as we get that document back from Riverview PD regarding court-appointed attorney appointed attorney for felony matters, the court will sign that. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything else you may say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, ma'am.
The court's entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference on May 8th at 9:45 a.m. And counsel, I'll give you an opportunity to argue bond.
Yes, sir. I'm just writing this down. Your Honor, I also want to note that on the information that I saw, there's also an habitual second.
Yes, there is, and additional seconds for identity theft, something or other.
Yeah,
Lots of
that
them.
increases the penalty from the identity theft, but also there is a half second.
Correct,
Yeah,
there is, there's multiple, yes.
Oh, yes, thank you. Your Honor, he does have an extensive criminal record. He is not on probation or parole at this time, from what he's told me. I'm just indicating that the last case was resolved back in '24. He's self-employed. He no longer lives in Wyandotte. He lives with his sister, who is in E-course. The address is 45.
Don't put that on the record.
Oh, I'm sorry. And it may be on the petition. I just want to bring that to the court's attention. There is the habitual. At this point in time, we've asked for a bond that's commensurate with the situation. Also giving him the opportunity to be able to defend this particular matter. I'm not going to stand here and say, please give him a personal bond, which he asked me to give him, but something that is commensurate with the charges. I do understand he does have an extensive criminal record, and I've observed that from some time ago, and that there are outstanding warrants.
Okay, so Mr. Larsenis, how long have you been residing with your sister in E-course?
About a year and a half, no, about 3 years. I'd say. Year and a half.
Sir, I think that you were residing in Wyandotte at your last court date that you had here.
I'm sorry?
Weren't you just here last year?
No, ma'am.
23. Oh, 23. Have you changed your address with the Secretary of State?
No, I haven't. I was just waiting for my license to expire, honestly, because it's just coming up this year in August, and then having to make the appointments and all that, and transportation issues. But I have given that information to every legal matter I've associated myself with.
Well, sir, I have to tell you, I think you have the thickest file today. You have cases that go back to 1989.
Correct.
that are dealing with theft, sir. 1989, we're on almost almost 40 years. Almost 40 years, sir, of criminal history regarding theft.
Okay. I've
Don't say anything regarding this case.
People approaching 65 need to realize that choosing
If you were to test right now, sir, what is in your system?
I'm just like the personal bond, Your Honor, so I could try to pursue my legal matter of owning a lawn service where I'm trying to make money legally.
I can 100% guarantee that you are not getting a personal bond.
Well, could you get it as low as possible, please?
My question to you, sir, was if you were to test today, what is in your system?
Nothing.
He has been incarcerated. He's been in jail approximately 3 days, sir.
Okay.
Just want to bring that to your attention.
Well, so this is the third day, because if all this occurred on the 28th.
28th, yes, I'm just saying.
Okay.
Approximately.
And what happened with your matter from 23 from this court, sir? When you were bound over to circuit court?
I don't recall. My time served.
Oh, okay, well, you weren't on probation?
I was, and I completed it in the time served. It's closed, case is closed.
Well, October in Trenton. Well, wait a minute here. In October of 23, you pled guilty to felony. Actually, it's August 1st of 24 is when your probation was set to start. Felony identity theft out of the 33rd District Court. Felony financial transaction device illegal sale or use. And that was 18 months probation.
It's all been closed, Your Honor. It's all been closed.
That's been closed already?
Yes, ma'am. I've completed it and closed it. I'm on no probation.
Early discharge, right?
I don't know, it's been 9 months. When did you get, when was your probation concluded, sir?
February of this year, I believe.
6 months. Wow. Interesting. And then now you're suspected in another matter that's under investigation, and now you have these 16 counts. What, is that funny, sir?
I'm not guilty of these 16 counts. I'm sorry. But...
Well, sir, tell me about your probation from Third Circuit Court for felony possession of narcotics, where you were sentenced to 3 years probation. How is that already closed?
It's all been closed, Your Honor.
Has it been closed because you violated probation and they revoked it and you said you spent time served?
Yes, ma'am.
There we go. There we go.
It's all closed.
Okay, well, you led the court to believe that it was closed because you successfully completed it. But clearly, you violated probation and then it was revoked and then you were sentenced to incarceration for that. So, sir, you're being a little bit disingenuous with the fact that you're saying it's closed and completed. It's not completed. You didn't complete it. I'm sure it shows revoked probation, not probation closed without improvement. And you have a number of warrants for your arrest, sir. Why is that?
I don't know about the warrants.
Detective, do you know where the warrants are? Hold on, maybe I have them right here. I can tell you. I'll tell you right now, sir. Let's see. 23rd District Court from April of 24, you failed to appear for an arraignment pretrial.
What's the charge?
Possession.
Okay.
Then in 2023, you did not appear for your possession of heroin in the 25th District Court. Then April of 24, oh, this was the second one for this, so.
Misdemeanors.
Whether they're misdemeanors or not, sir, you still didn't show up to court. So
I
whether you
understand.
think this is a misdemeanor.
I'm just taking stuff notes, Your Honor. I'm not.
Excuse
to the
me,
court.
keep your mouth shut.
Then we have in the 24th District Court, January of this year, you failed to appear for court on your possession of drug paraphernalia. Then April, oh, just last week, you were supposed to have been in 23rd District Court.
For what?
Arraignment pretrial.
For what?
Oh, the warrant was issued last week, but you're supposed to have been there April 9th. I'm not sure, it doesn't show what it was for, sir.
Your Honor, it says obstructing police, I believe, for that one.
Oh, that's a,
Oh, there it is, obstruct police, yes, okay. So, sir, I have to tell you, the board has some serious concerns for the safety of the public. As well as your ability to return to court. Detective, would you like to address bond?
Your Honor, I think just because of the harm he's the harm he's caused to the city of Riverview's residents in this case, and not only likely the case in March, his extensive criminal history, obviously a history of not showing up to court. I would ask for a $25,000 cash bond, as well as, if he is able to make that bond, electronic monitoring through the tether system in Wayne County.
Yeah.
Mr. Larsenes, you seem to be making a lot of noise while the detective is speaking. I'm not sure if that's sighing or chuckling or what that may be, sir. In addition to your criminal history, the court has 34 entries of cases in this court going back to 2006. Possession of paraphernalias, loitering, larcenies, possession, driving while license suspended, interfering, reckless driving. Okay, so here's what the court's going to do. The court, after hearing from counsel, hearing from Mr. Larsenes, hearing from Detective Herrick, reviewing the criminal history, the extensive criminal history, the number of times that Mr. Larsenes has failed to appear in court, failed to complete probation, and given the court's concern with the safety of the public, this court is going to order a $250,000 cash bond. You're not to have any contact with any of the complaining witnesses in this matter. That's Elizabeth Ashley, Matthew Ashley, Alan Owens, Austin Robinson. That's phone contact, text message, email, social media, third party, anything of the like. You are not to return to the premises to the homes on Meadow Street or Hilltop Lane. You are not to possess or consume any alcohol or drugs unless prescribed. You're not to have access to firearms and or any weapons. And you, in the event you post bond, you are not to be released without GPS tether house arrest through the Wayne County Jail.
Your Honor, would the court at least consider the amount I'm not quibbling with, but would the court at least consider a surety?
No.
With that cash?
The court will not consider a surety because Mr. Larsenes has shown that he is unable to appear in court, as well as the fact that he has 4 aliases as well.
Just
and now
asking
we
you.
are here at 16 counts of charges that are similar in nature to ones he was just convicted of last year. as well as, littered throughout his criminal history. And what is that, Mr. Leslie?
Thank you, Your Honor.
What is that, sir?
I'm not guilty of none of this.
Well, now you'll have to.
You guys are calling me guilty and I'm not even guilty.
No, sir. No, sir. I've heard.
It sounds like you are. You're coming at me as if I have done this. I have not done this.
Sir, I have heard evidence that has been put forward that supports probable cause to believe that crimes were committed and you have committed those offenses. Based upon that, the court
picked out of a crowd walking through a field.
with the arraignment.
They looked at my record and said, yes, this is him.
And the court also taking into account your criminal history and your.
I've already did my time for them. Why is that used against me again? That's illegal.
Sir, that's not illegal. That is a factor.
Yes, it is.
That is a factor that this court is required to take into consideration when determining bond. And in this case, your criminal history is so significant with the same types of charges that you're currently charged with, that this court has concern for the safety of the community. So that is the order of the court. You'll be back on May 8th at 9:45 a.m.
Thank you, Your Honor.
Have a good day.
Thank you, Your Honor.
Thank you.
Okay.
All clothing is
Okay, well, you were sentenced in March.
I know.
Counsel, your client hasn't done anything.
I understand, Your Honor.
She has done zero. We're on the record in the matter of Dina Wise, 2323658. For B, I mean. This one's B.
Ms. Wise, would you please put your name on the record?
Dina Maria Wise.
Okay, and so today's the date for the probation violation hearing. Counsel, do you have the sheet? Do you have that sheet, their handwritten sheet?
Their handwritten sheet.
Yes, you know the handwritten probation violation sheet that they do that's in the file?
I have a copy that was, I haven't seen that file. Approach.
Yeah, that.
Yeah, this was emailed to me. I didn't.
No, I'm not saying you did.
I'm just thinking.
Nope, it's right here, somehow it got put into the file. Okay. All right, so the allegations in this matter, so first, your client's on probation for possession of controlled substance. This is alleging technical violations 1 through 5. So alleging your client failed to appear for probation visit December 3rd, failed to appear chemical awareness program on December 2nd, failed to appear for drug testing December 3rd, December 16th, and December 26th. And counsel?
That is correct, Your Honor. I discussed this matter with Ms. Wise. I've advised her of her right to a hearing in this particular matter, and I've also advised her of her constitutional rights. Discussing this with Ms. Wise, it's my understanding that she would plead guilty to the violations, and through this plea, beg for the court's mercy, because you'll hear what's going on in her life.
Ms. Wise, please raise your right hand. And you heard the allegations that were placed on the record, correct?
Pardon?
You heard the allegations that were placed on the record, correct?
Yes.
I'm under the weather. And as to those allegations, how do you plead?
I plead guilty.
And you've gone over your advice of rights for probation violation purposes, correct?
I have, yes.
And you understand all of these rights?
I do.
And you also understand by entering into a plea, you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea to this probation violation, and that the recommendation is for your under advisement status to be revoked, your probation to be revoked, case closed without improvement, $50 probation violation fee, and 20 days jail. Do you understand that's the recommendation?
Yes.
And knowing all that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or forced you in any way for you to enter into a plea today, ma'am?
No.
All right, counsel, if you can please argue your client.
Thank you. Ms. Wise, you're placed on probation to this court, is that correct?
Yes.
And as part of the terms and conditions of your probation, you were to attend probation meetings, chemical awareness program, and submit to drug testing, is that correct?
Yes.
And on December 3rd, did you fail to appear for probation?
I did.
And on December 2nd, did you fail to attend a chemical awareness program?
I did.
And on December 3rd, did you also fail to submit to a drug test?
I did.
And did you fail to submit to drug testing on the 16th and the 26th of December as well?
Yes.
Defense satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violations 1 through 5 will enter. And counsel, ask the recommendation.
Your Honor, the whole last year, speaking to Ms. Wise, has been somewhat of a disaster. She's trying to get her life turned around. She's trying to get everything straightened out within her life. Her family life is basically going to extreme language hell. In the last month or two, her husband, who is her sole support, pays all the bills, takes care of all the business. They have now finally separated. She has no money to file for divorce. He comes and goes, doesn't take care of anything except himself, it appears. She lost 2 jobs over the last few months. In fact, she lost her job approximately a month ago. She is trying to get employed, but more importantly, she's trying to get her head turned on straight. She knows she needs these programs. The recommendation is to revoke and also to revoke the under advisement status. If that happens, then of course there'll be not only the other consequences from this court, but also this would now affect her driver's license because of the drug-related matter. She is trying to get another work. She has an appointment scheduled to enter into some sort of self-employment arrangement. She's meeting with, I guess, her niece. Pardon?
My cousin.
Your cousin, who is a paralegal to help draw up the paperwork. This is, and I'm just reviewing what I've reviewed. She's been on probation for approximately, I'm sorry, Your Honor, when was she placed on probation?
March, yeah, February.
March. And this is the first time she's violated probation, or, there's been violations, so here she's been struggling through all of these 9 months. I know there's things that have to be done, but I don't know if revoking her advisement status, putting her in jail, and revoking probation is the appropriate way to go. If the court feels because of this that there is a need for some sort of jail review, or at least jail, ending her probation is not going to solve the question. It's just going to put her in jail, and she'll owe you money. I'm asking rather that probation be continued, that the under advisement status be continued, and she'd be able to turn herself around, get a job, at least get the support she's owed from her husband so she can make these payments, and suspend any kind of jail sentence at this time.
Okay, let me ask these questions to you, ma'am. Have you been attending the fan meetings?
I have not. I haven't. And I apologize. I have never.
Excuse me, it's yes or no? It was yes or no? Have you had any mental health counseling?
No, I have not. I've seeked out someone and I'm pretty sure it's just money. I don't have any money.
No, ma'am.
Yes.
Do you have any health insurance?
I do have health insurance. So with the counseling, which I know I need immensely. She is seeing if my insurance, which I have Aetna through the state, to see if she will accept that. Because I really like this one.
Yeah. When did you start that process?
This around Christmas time.
Okay, well, you were sentenced in March.
I know.
Counsel, your client hasn't done anything.
I understand, Your Honor.
She has done zero. And in fact, the court even at sentencing indicated mandatory revocation of under advisement status for any violation. So, when's the last time you saw your probation officer, ma'am?
I seen her last year, well, December. No, excuse me. Oh, November. In November, and I was supposed to see her in December. It's been extremely hard the past 2 months. My gas got shut off. It's nobody's problem. I take accountability. I just know I don't deserve anything. I don't deserve it. However, I believe I'm worth it. I've never given it a chance.
So your client, other than meeting with probation once a month, has done nothing. And quite honestly, I think the violation should have come forth a little bit sooner regarding not attending fan meetings and not having mental health counseling.
May I have another chance? I know I can do it. I don't hurt anybody. I don't bother anybody. And I just have always been hard-headed as far as what people think I need. But sometimes people know what's best for me, you know? And I'm just ready to do that. I'm ready 100%.
Okay, good. I'm going to order 20 days jail. I'll suspend 15. She's going to serve 5. And we'll continue probation. Under advisement status is revoked per the court's previous order of probation. And
Your Honor, would the court reconsider that aspect of it?
No.
I don't have anybody to take care of I don't have anything. Please.
Ma'am?
Please. Yes.
What do you need? What do you need somebody to take care of?
My home, everything, just everything.
Well,
could you please reconsider, please? Like I said, I don't deserve it. I know I don't.
Excuse me. Let me just clarify, ma'am. You haven't done any of your mental health counseling.
But I will.
I will. Stop. It's my turn to speak.
Okay.
When I crafted your sentence, I took into account all of your needs. I crafted the sentence according to your needs.
Okay.
You blew a lot of those needs off. You didn't go to your fan meetings. You didn't attend mental health counseling. And for the month of December, you pretty much did nothing that you were supposed to do.
Yeah, I'm a jerk.
Please stop. You were given the benefit of the under advisement status. And I ordered at that time, if there are any violations, you are going to lose that under advisement status. So you now have 5 violations. I absolutely am not going to continue the under advisement status. You had much notice, and quite frankly, you should feel fortunate in the sense that you weren't before the court previously for probation violations because you were not attending fan and you were not attending mental health counseling. And you have insurance.
Your Honor.
I'm going to order 20 days jail. I'm suspending 15. You can report Friday, January 10th. That gives you a couple days to arrange for somebody to take care of your house.
Okay.
I'm going to continue your probation. I'm also going to extend it 6 months from your original end date.
Okay.
You are to enroll in mental health counseling.
Okay.
Within 24 hours of today, because you know when you're going to be out of jail.
Okay. Pardon, what was that? What did you just say?
you are to enroll in mental health counseling within 24 hours. So
Okay.
today, you need to email into your probation officer with the date of your screening with your mental health provider.
Okay.
And I'm going to go out on a limb here and ask if you've performed any of your community service hours.
I have not.
I didn't think so.
I know. I apologize. Sincerely, I do. I know you've heard it all.
You are to attend the fan meetings beginning Thursday, January 16th. No excuses, ma'am. 0.
Okay.
0. One more violation, ma'am. And this is all out the window. You're serving the balance of your 15 days and any other days that this court adds on.
Okay.
If
May
you
I?
were to test right now, what's in your system?
Okay.
If you were to test right now, what is in your system?
There's no alcohol and maybe some Adderall. I'm just completely lost. That's all. That's honest.
Are you prescribed Adderall?
I am not.
Okay.
I am not.
So here's what I'm going to do, counsel. I'm going to reverse it. I'm going to have your client serve the 15 days, suspend 5, which is to be tethered to treatment through the Wayne County Jail. That will be a jump start on her treatment that she needs so desperately, that she's also indicating that she really wants.
Same report date.
Your Honor. Your Honor.
Yes.
May I say that I've never had trouble with drugs. Once in a while, I'll, get down on myself and do something. My thing is, and please hear me, my thing is trauma. I haven't dealt with it. That's my thing. It's not drugs. It's trauma. And then trauma for me leads to me being irresponsible, like so as today. And from the time I've seen you with this case, it's the trauma. And I deflect all of the time. It's not drugs. It's me, a personal thing in my head, things that have happened to me in my past, and they're extreme. And I just feel like everybody goes at the wrong thing with me when I'm telling you now, and just sort of reaching out for help when it comes to I need counseling. I desperately need counseling. And I know if I go to like these meetings like you're talking about and asking me to go to and ordering me to go to, I know I have to give forth and put effort. I know I do, and I want to. I'm 46 years old, and I've never admitted that I need counseling and I need help, because I'm okay. I can put things down. I can leave things alone. I just don't deal with my trauma, and I need help with that. It's always been ignored my whole entire life, since I was a little girl, since I was 5 years old. Just ignore it and kind of go for what the big thing that's in everybody's face. But I'm here telling you as a woman, and I know my position in life, but I just need help with my trauma. I have a lot of trauma.
Okay, and ma'am, I can appreciate that.
Oh, it's hard to hear you. It's hard to hear you.
I said I can appreciate that. However, you were afforded an opportunity.
Your Honor, I have to put my phone on the charger. I apologize. I'm taking you with me.
You are afforded.
And it's hard to hear you because. Yeah.
So, ma'am,
Okay.
you were afforded an
Okay.
opportunity.
Well,
You were afforded.
there
You were afforded an opportunity, ma'am. Okay, I don't really want to look into your ear canal, please.
I know I was.
And
Like I said,
I let you speak.
I'm not trying to.
Please let me speak. But before I do that, have you ever lived in Florida?
Okay.
Have you? Okay.
I've
so
been to Florida, yes.
Do you have another last
Yes.
name that you're known by?
My maiden name?
Yes. Which was?
Yes. Yes, ma'am. Absolutely.
So you're telling this court that you don't have a drug problem, that drugs isn't your thing. However, there are some drug convictions from Florida. And you're here for possession of controlled substance charge. And
it was drug paraphernalia. It wasn't an actual drug.
Ma'am, you're deflecting, right?
Yes.
So you see that that your coping is deflecting, but you continue to deflect. So I'm going to help you, and you're going to report to Wayne County Jail on Friday. You're going to serve 15 days. You're going to be tethered to treatment. The court is going to suspend 5. Your under advisement is revoked because, quite frankly, I'm not sure how you even got the under advisement since you have prior drug convictions from Florida. But in any event, that was recommended, so perhaps that wasn't caught the first time, I don't know. However, all the other things that I stated are going to remain, except for the fan meeting. You obviously won't be out to attend that. You need to attend the fan meeting beginning in February.
Okay,
if you do not report to jail on Friday, the warrant will be issued for your arrest. So you're going to
I understand.
You're going to email into Miss Shine, and she will give you the instructions as how to report. Okay?
Okay.
So I expect that you'll be at the February 20th fan meeting.
February 20th. Okay.
Yes.
Your Honor, I would like to apologize to you for if it seems I'm being disrespectful and ugly. Because I'm not.
Nope. No apology necessary. You're fine.
Yeah.
All right. Email into Miss Shine by 1:30.
Thank you. Good luck.
Yes, today.
Okay, I'll email her. Thank you.
Thank you. That is all on you. You made the choice to use marijuana. You made the choice to consume alcohol. We are going to go on the record in the matter of the city of Wyandotte versus Cameron Walston, 211554. And appearance for Mr. Walston.
Attorney Corey Westmoreland, appearing on behalf of Cameron Walston. Mr. Walston, would
your name, please?
Cameron Walston.
All right, today's scheduled for a probation violation and a jail review. So, Mr. Walston was here let's see. Well, first, on May 2nd, the court accepted his plea of guilty to a probation violation and set this matter for a jail review on June 13th. On June 13th, we held the jail review. We adjourned it for 2 months, which would be next week. However, because there was another violation alleged, the next week's jail review was moved up to today's date. So we're handling everything today. And I'm not sure what that noise is. I don't know what that noise is. Are you driving, Mr. Walston?
Oh yeah, my car. I just was on lunch break. I was in my car.
Okay, just make sure your windows are rolled up or your air conditioning. I just can't have any fans or something like that going on.
All right.
And so the May 2nd violation hearing that initiated the jail review was because there was 2 tests that indicated use of marijuana. And now the allegation is that you tested positive for alcohol and marijuana and failed to appear for drug testing. And so, counsel, what's happening with the probation violation?
Yes, Your Honor, after speaking with Mr. Walston, At this time, we are prepared to enter a guilty plea to the alleged allegations on July 19th and July 27th.
And what about deposit of alcohol from June 20th?
Oh, yep, and June 20th as well. I did go over his rights. He understands he does have a right to have a contested hearing on these matters, but we are prepared to waive that at this time.
Thank you. Mr. Walston, please raise your right hand. You solemnly swear from the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
Okay. And you heard the plea your attorney indicated regarding the allegations, correct?
Correct.
All right. And as to the allegations, you tested positive for alcohol on June 20th of 22, tested positive for marijuana on July 27th of 22, and failed to appear for drug testing July 19th of 2022. How do you plead?
Guilty.
And you've also gone over the possible penalty as a result of your plea, specifically the recommendation for you to serve 15 days jail.
Yes. Yeah.
And knowing all that, you still want to continue with the plea.
Yes.
All right, counsel, if you can please swear to your client.
Sure. Mr. Walston, is it true that you're currently on probation out of the Wyandotte District Court?
Yes.
As a term and condition of probation, you understand that you're not supposed to test positive for drugs or alcohol, and you're supposed to drug test as ordered by probation?
Yes.
Is it true that you tested positive for alcohol on June 20th of this year?
Yes.
Did you also fail to submit to a drug test as ordered on July 19th?
Yes.
And then did you also test positive for marijuana on July 27th of this year?
Yes.
Okay. And you understand that all those are in direct violation of your probation?
Yes.
Satisfied, Your Honor.
All right, the court is also satisfied. The plea is knowing, voluntary, and factually accurate. And as to the recommendation, counsel?
As to the recommendation, Your Honor, at this time, we would be seeking leniency on behalf of my client. He understands what he did was wrong. He turned to drugs and alcohol briefly because he was going through some hard times with the mother of one of his children. I would like you to know that he is currently working full-time at he does have 3 children that he is solely responsible for, and any sort of jail time would potentially create a very, very problematic situation for him and his family.
Well, here's the thing. This is Mr. Walston's 3rd violation. Mr. Walston, this court gave you an opportunity to stay out of jail. I could have sent you to jail back in May, but I did it as a jail review to give you an opportunity to show the court why you should not be in jail. And yet, what did you do? You consumed alcohol, you consumed marijuana, and then you failed to appear for testing. What is it you had to drink before your test that you took on June 20th?
I believe that I had got into it with my baby mom, and I had just got out. It might have just still been in my system because I don't believe I drank anything.
What would it have been? Sir, that doesn't make any sense. What would it have been? What would have been in your system for alcohol since you can't use alcohol at all?
Right. I suffer from major depression, Your Honor. Even though I know I'm supposed to, refrain from alcohol, at times it just gets so hard. And I did slip up on seeing my therapist because it's been so much going on for me lately. So I kind of slipped on appointments with that because I have to work. Yeah, just trying to make the best of everything, I guess.
Okay, let me just put this into perspective for you, Mr. Wilson. You have to work, you're saying. And in order for you to work, you need to not be in jail. And in order for you to not be in jail, you need to comply with the conditions of probation. In order for you to do that, you clearly need to be seeing your therapist on a regular basis. So that should not be something that you're putting to the side. Does that make sense how it's put in that perspective?
Your Honor, I understand what you're Same.
And then you tested positive for marijuana. You don't have a prescription for marijuana, do you?
Yes, but you guys told me it wasn't enough, sufficient enough.
Well, because you didn't get that prescription from your treating physician, correct?
The one who prescribed it from me is my primary prescriber, but my primary physician is in Henry Ford, and they weren't able to give me the necessary documents, I guess.
Why didn't you appear for your drug test on July 19th?
I'm currently in debt right now. I'm working out of getting out of debt. I take care of not only my 3 children, but I take care of my nieces and my nephew. I just actually bought a vehicle, so on top of bills, plus debt, I wasn't able to make it to. I didn't have the $20 to go drop, and that's the reason, Your Honor.
And did you email your probation officer to let her know that?
Yes, I did.
And see if there was another option?
She said it wasn't no option.
This court's given you quite a few chances, sir.
I know.
And so the court's going to adopt the recommendation. What's that?
I'm sorry, Your Honor. I didn't mean to cut you off.
No, go ahead. What's that?
I was just saying, if the court will find it in their hearts to give me just one more chance, it'll be much appreciated on my behalf, because I will be able to, continue to take care of my responsibilities. With the 15 days in jail, it's a very possibility that not only would I lose, what I've been working for, but lose my job.
Okay, but sir, that is all on you. It's all on you. You made the choice to use marijuana without being approved. You made the choice to consume alcohol. You're on probation. You already have a jail review. The court, I gave you a couple of chances. You were sentenced in this court February 14th. Since then, you had a probation violation hearing May 2nd, to which this court did the jail review. We held the jail review a month after that. We adjourned it for 2 months. Then, only a week after the jail review was held, you tested positive for alcohol.
And I know it doesn't look good on my behalf, but I've been, when I had my last jail review, I was doing good. It sucks that, I kind of lost track of time and stopped not associating, but setting up my appointment with my therapist during that time afterwards. And I kind of just, not having that outlet kind of consumed me.
And sir, how much paid time off do you get?
None.
How long have you been at your employment?
I just actually found a better opportunity. So right now I'm still fresh. But I've been working this whole time, and I found a better opportunity that's closer by where I stay. So I went ahead and took that opportunity.
And where is that?
And Taylor?
Well, you have to check with your boss about having some time off, even if it's unpaid. So the court's going to indicate that you're continuing to complete our terms of probation, $50 probation violation fee, 15 days jail. I'll give you until August 19th to report, so that gives you about a week and a half, sir, to figure that part out. And so that's 10 days jail from this matter, this violation, as it's your third violation. And also the 5 days from the jail review. You're gonna serve the 5 days. So I certainly hope when you're done, that you can successfully complete probation without any more jail time. Anything else, counsel?
Not this time, Your Honor.
All right, sir, email into Michelle, and she will let you know how to go about reporting next Friday.
Where do I report to?
She's going to give you all that information. So if you just email her one day next week, she can give you that information. It's where you need to report. Okay.
Thank you, Judge.
Thank you.
If you want to forfeit that,
Yo, what's up, guys? So I'm
Do not address Mr. Howard.
Excuse
Do
me?
not address Mr. Howard. State of Michigan versus Perry Howard, 211444. Mr. Westmoreland's present, Mr. Kazak's present, Ms. Pinkston's present, Mr. Howard's present. Ms. Pinkston, can you sit somewhere other than your bed, please?
Pardon me?
Can you please sit somewhere else other than your bed?
Can I sit where?
Somewhere other than your bed. All right, thank you. Okay, and so where we left off last time in April was that Ms. Pinkston was indicating that the entire amount that was requested for the repairs, that entire amount was of damage was caused by Mr. Howard. Is that
yes
where we left off?
That's correct, Your Honor.
Okay.
Ms. Pinkston, thank you for coming here today. I'm back on the 30th of October of 2020. You indicated that Mr. Perry had come over to your apartment and had caused some damage to your vehicle. Is that correct?
No, I came over to his to get my belongings and my keys to my home. In the midst of that, he was enraged. It looked like he's been drinking. He pounded on my glass door of my window on the passenger side. He jarred the doorknob several times, multiple times, before he kicked the door.
All right. And when he kicked the door, did that leave some damage on the door of the vehicle?
Yes, it did. It left his footprint, his boot print that he had on, that he was wearing at the time. I took pictures of it, submitted to the officer, the sergeant that was on duty at the time. And in the midst of that Monday morning, I took my vehicle to Feldman Chevrolet to get an estimate of what the damages will be, and that's what they gave me. I submitted them to the court. After that, court proceedings were still in limbo because of COVID and everything as far as that. And then once the prosecuting attorney reached out to me and told me I had to get it fixed in order to get restitution.
And so now you indicated that he kicked your door. Is that your driver's side door?
No, the passenger side. Everything was done on the passenger side.
Did he kick or strike any other portion of your vehicle at all?
The window on the same side, and he jarred the door handle several times. He pounded on the glass several times before he kicked the door. He intentionally did it deliberately.
And was the only damage done by Mr. Howard with regard to your vehicle the front passenger door.
Yeah, everything that he previous done before that, before he kicked it, yes. And I had no damages to my vehicle before he did what he did.
I object.
Now, in
Mr. Howard, you have an attorney that can object for you.
Oh, okay, I'm sorry.
Now, you indicated that you went to the Feldman Chevrolet in Livonia and got an estimate for the repairs. Is that right?
Correct.
Now, there were some in the estimate that you provided to the court. There were some repairs that were indicated in the report that included the rear door and the fender.
Well, like I said, I'm not an auto body mechanic. All I know is what the damage they did.
Ms. Pinkston, please let Mr. Kazak finish the question before you start answering, because my court recorder can't take two things out at the same time. Okay, so please let him finish the question before you start answering.
And so do you know what those the fender and the rear door repairs were specifically for with regard to damage were specifically for or not?
From my estimate and from my knowledge, they had to take the whole door panel off and replace all of that from the damage that he did.
And you've indicated that you had no other damage to your vehicle prior to Mr. Howard kicking in your door. Is that right?
That is absolutely 100% correct.
Your Honor, I don't have any further questions at this time.
And Mr. Westmoreland?
Yes, just for clarification, what door did Mr. Howard kick?
It was the front passenger door.
And how many times did he kick the door?
He only kicked the door once.
Do you recall what type of shoe he was wearing that day?
He had an ankle boot on. Brown leather ankle boot.
Is it like a work boot or a dress
No.
shoe?
No, it's a dress boot.
So you're saying that he just kicked the front passenger door one time? He never kicked the fender or the rear door?
He dented it pretty bad. So before that, he had jarred the window and the door handle.
Correct, but he just kicked the front passenger door. That was the only place he kicked?
Yes, with a strong, heavy kick.
No other questions, Judge.
Any other witnesses that you plan on calling, Mr. Kazak?
No, Your Honor. We have no further witnesses.
Any witnesses you'd like to call, Mr. Westmoreland?
Well, the holidays have come.
I don't believe so at this time.
I have a question, Ms. Kingston, about how long did this interaction last?
For about 20 minutes before he chased me down Biddle. So prior for that, I should have been charging assault charges as far as fearing for my life, but I didn't. All I want him to do is pay for the damage he's done to my car.
Yeah, Ms. Kingston, please answer the question I've asked.
About 20 minutes.
All right, and where did, when you took the photos that were of the damage, where were you?
Where was I? After
Yes.
After I wind up losing him, I regained myself, went over one of my girlfriend's house to collect my thoughts.
Ms. Kingston,
Over
Ms.
a
Kingston,
friend's house.
please answer, Ms. Kingston, please
Over a
answer my
friend.
question.
Over a
Please
friend's house.
answer, excuse me, please answer the question I've asked specifically without extra information. So you went to a friend's house to take these photographs?
Yes.
Did anybody else take any photographs? Any detectives or officers?
Yes.
And there wasn't any damage done to your vehicle prior to Mr. Howard kicking it?
Correct.
And how much time after you took your photographs did the detective take photographs or an officer take photographs?
Probably no more than a half an hour later, 45 minutes later.
Well, what we had adjourned this matter for was so somebody from the dealership would come in and testify because, number one, as it relates to the invoice, there's stuff on here regarding a fender and whatnot, but there hasn't been any testimony regarding any damage to the fender. And so I don't know why that would have been why that would have been repaired. And second, and the photograph that Ms. Pinkston took, which looks like it's shown, there's a picture of her, like a screenshot of some sort, because it shows it like from her phone. There is a boot print, but then the photograph taken from the officer that was emailed to Ms. Shaw of our probation department does not show a boot print. And I really would like to know from the repair individual how a kick would cause the door to not close all the way when the kick was in the middle of the door.
Well, can I answer that? He ajarred my door handle before he kicked the door.
I
He
see
yanked
that
on
with the
my-
door handle. I see the door handle, but I'm wondering with the door itself, are you indicating the door handle will not, because the door handle is stuck out, it will not permit the door to close all the way?
I'm not an auto body mechanic. I have no idea. All I
Right,
know
that's
is
why
what I saw, what he did.
Right, that's why I really needed the auto body person to come in. I mean, Mr. Peary or Mr. Howard definitely damaged the door. But there's going to have to be a recalculation done because the right fender liner, the right wheel opening molding, from what I understand, the fender is the part between the door and the front bumper, is my understanding of the fender. And there isn't any testimony regarding that. There isn't even any evidence regarding that. So when you take out 0.4 for labor for the right fender liner, right wheel opening molding, and a 1.0 for the paint, I don't know what the right blackout tape rear is for, what that's for, because there was no damage. There's no testimony regarding anything rear. Did they have to replace the entire door, ma'am?
Yes, correct. Yes, they did. They replaced the whole door, the whole entire panel.
So it would make sense for the mirror assembly. Okay, that would make sense. The handle. But I'm confused. Well, I guess they have to replace the handle because the door doesn't come with a handle apparently.
From my understanding, they had to paint the door. They had to spray the other side for it to match up with that.
Ma'am, how did they even get to the $2,400 or the $2,200 amount? $2,488.59. Where did that amount even come from? But these subtotals total $1,012.75.
That's just for the parts, Your Honor, I believe. The rest of the cost was for the labor.
Okay, so the parts were $936.75, and then the labor. Okay, so did you figure out how much labor was? So if you take these labor amounts and you multiply those by $50 an hour plus the $936.75, $1,241.75. Because I don't have any evidence before this court regarding the rear door. There hasn't been any testimony regarding the rear door. You don't have anything from the
For the fender.
From the what?
For the fender as well.
Correct. Or the fender. And we don't have anything from the body shop people. They're not here to testify. And so the court's going to indicate restitution around $1,241.75.
Well, I want to file a motion because it's not fair. It's not fair at all. He kicked my door out of rage.
Ms. Pinkston, your testimony, as well as your statement that's in the police report, as well as the estimate that's put forth, shows the amount that was caused, the amount that was charged for the right passenger door. There wasn't any testimony about anything with the fender nor the rear door. This court cannot order restitution on the fender or the rear door without having any evidence that that was caused by Mr. Howard. Mr. Kazak subpoenaed the body shop person. They did not appear. I cannot assume what that person is going to say. I need to have it on the record for evidence. And that's what I need to base my ruling on.
Well, I want another court date because this is not fair. I have to come out of my pocket for some here 10 doing maliciously, let no one. I mean, this is preposterous. Just keep going through all this for nothing.
Yeah,
He did it.
Ms. Pinkston, at this time, this is the court's ruling. If you have some other evidence that would suggest that the additional money is from Mr. Howard's actions, then you can certainly present it to the prosecutor.
And I will.
But at this point, what the court has, and I adjourned this from April, I believe, so that the person can be present and that person is not present.
If a donation makes sense for you right now,
So therefore, the court's order is restitution in the amount of $1,241.75. Thank you very much. And we're going to be off the record.
You're going to get yours.
Don't make threats. You're in court.
I ain't making threats. You are. Karma is something. Karma is something else.
Listen, that's not going to happen. You can remove yourself from the meeting. Do not make threats. Do not anything. That's not acceptable at all.
Tell him don't make threats and quit calling my damn phone.
Ma'am, you're in court. You need to have appropriate language.
Excuse me, Your Honor. Can I say something?
I have
we're not on the record.
That you left. I have voice message that you left. So don't play with me.
Hold on, stop. Do not address Mr. Howard.
Excuse
me?
Do
not address Mr. Howard.
I love the prosecutors.
Yes, Mr. Howard, your attorney is still present. What would you like the court to know? We can go back on the record. Yes, Mr. Howard.
Yes, I would like to put a PPO out on her.
Well, this is not the jurisdiction for that. You have to do that with Third Circuit Court.
I will be down to the court.
And I need to put one out on you. How about that?
Listen, ma'am, I said not to address Mr. Howard.
Now, this is ridiculous. I amended the part that I played, but she never did.
You played a little part. You maliciously take mine down.
Miss Pinkston.
Why
that's
the fuck
enough.
you?
No,
Why
Mr.
the
Howard,
fuck?
that's it. Mr. Howard, I understand you pled guilty. I've assessed your restitution. If you feel the need to get a PPO, then you need to take that to the Third Circuit Court.
Yes, I will.
District Court does not have jurisdiction over that.
I will. Am I done here?
All right. You're all set. Yes, thank you. Off the
Thank
record.
you. Have a good day.
It's unfair. Karma is something. Karma is something. Karma is something. How about that?
Oh, I knew that was.
Wow. Wow. So that's it for today, ladies and gentlemen. If you're Now, if you like the content that's on this channel, please do me a big, huge favor and subscribe to this channel and help this channel grow. I'll be here tomorrow at the same time. So you all have a wonderful evening. Ta-ta and ciao, ciao. I will see you again tomorrow.